Appeal in for the 5th District of the State of Florida is now in session. The Honorable Harvey L.J. Judge presiding. All persons having business before the court draw near, give attention and will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. As you may know, my name is Harvey J. I'm the presiding judge in this case. I have two esteemed colleagues with me, Judge Boatwright to my right, Judge McIver to my left. As I understand it, this is our first time at OA collectively. We've had cases together, but this is our first OA where the three of us are on the panel. So as I was telling my colleagues in the back, mark the time and date for that. It is historic in that sense. Thank you for being here on time. As I understand it, there will be 20 minutes per side. Thank you for being responsive to our questions, because that's why you're here, for us to ask you questions, because if it was not for that, we could have made a decision on the briefs themselves. If you're ready, Mr. Lee, for the first case of the day, you're welcome to come forward. And for the record, that case is Tiki Williams versus Weaver, case number 23-324. Mr. Lee, how much time would you like to have for rebuttal?
I would like 5 minutes for rebuttal.
5. When you're ready, please proceed.
Thank you, Judge Jay. May it please the court. My name is Brian Lee. I am representing Tiki Williams in this appeal from a summary judgment that was entered by the trial court. There are multiple reasons why we believe that the trial court committed error in entering that summary judgment, and they range from the duty of care the judge used for Mr. Weaver, who was the defendant, as well as what we believe was improperly weighing evidence as he did so, or as the judge did so. The first point that we believe was erroneously done by the trial court, including the duty of care. The trial court used an independent contractor duty of care rather than a duty of care for business invitees. We believe that that was an error because Mr. Williams, when he was coming up to the house to give Mr. Weaver paperwork, he slipped on a deck that had algae on it.
To understand,
yes,
Mr. Lee, as I perceive your argument, it would be your position that the independent contractor standard should not apply because your client was not there to work on the deck. He was there to work on the grass, and it was not incidental to his work for Mr. Weaver to work on the deck. Did I understand that properly?
Yes, and I think it's even beyond that, is because the injury occurred, and I think it's undisputed, or at least the fall, occurred because of the algae that was on the deck.
Isn't he still in the scope of his employment? I mean, he's still in the scope of the employment as he's finishing the job and taking the paperwork up. Does that make a difference?
I don't think it does in our circumstance, because he was not injured. Let me kind of shift and maybe put it another way. If the facts was that he was walking on the grass, and the grass is what he does. He does the pest control, and he does that type of stuff. If he was walking on the grass and he slipped in the grass, or he stepped in a hole in the grass, and as he was walking up to the door, I think that would be a better argument that, look, that's what he does his work on. He doesn't do work on holes, but he does his work in the grass. We know that he was not hired, and his company was never hired to clean the algae that was on the deck.
But he was there
or the deck itself.
He was there to deliver paperwork as part of his job, correct?
That's right. He was actually, I believe the testimony was he was going to start his pest control job.
So he was on the property as part of his job, correct?
That's correct.
Okay.
But there's a difference between when you, because he's a business invitee in both circumstances. What makes you a business invitee versus an independent contractor duty of care is that you have to be injured under the independent contractor duty of care because of the thing you're there for.
So the complaint.
Delivering
was originally-
paperwork, sorry.
Go ahead. Go ahead.
Delivering paperwork. That's the thing he was there for.
I don't think, but he wasn't there to, he wasn't there to clean, he wasn't injured by that. He was injured by the deck, by the algae that was on the deck. He never had any work to do with that deck. So as he slips on the algae, he's hurt by something that's not within his scope of work. He's just walking, he's essentially injured by access to the premises.
Being on the property and delivering paperwork for billing was not part of his scope of work?
It was. But
I'm not getting your argument.
But what I'm saying is that when you're talking about an independent contractor analysis, you have to look at what caused the injury. He was not there to, and the classic example of this is a roofer who goes on the roof because the homeowner told him that there was holes in the roof, and he falls through a hole in the roof. That's an independent contractor duty of care because he was there to do that work. The mechanism of his injury was what he was there to do. The mechanism of his injury was not, even if he was there merely just to give paperwork, slipping on algae on a deck is not what he was there to do.
So the complaint originally filed says that he was there to work on the patio. Is that the same thing as this deck?
I don't believe it is, and even if tangentially the allegations were that way, the evidence certainly bore out that he never did any work on this deck.
And I understand your argument, Mr. Lee. I think we all do well. But assuming he was in the course and scope of his independent contractor relationship with Mr. Weaver, how does that change the standard here? What would the standard that we would need to apply to the evaluation of Judge Robertson's order judgment be?
Sure. So he would have to, so if he's part of the independent contractor analysis, then you have to go to some of the exceptions that are there. And one of them is where the owner was in control of the work or was like in direct control. There's really no evidence of that there. But then the other part of it is we get into then, okay, well, what are the duties of care that an owner has? And as borne out through the case law, the owner still has the duty to maintain his property. That doesn't go away because of an independent contractor. And the reason it doesn't is because the owner has the duty to warn Mr. Williams of dangers that he couldn't perceive or he couldn't or reasonably could know about. The evidence in the case, and it's been a little skewed, but I believe if you look at the evidence that we have, the evidence is Mr. Williams did not know about the algae on the deck until he already fell. He knew that he could see the deck. We have a picture of it. You know, is it the pristine deck? No, it's not. But he did not know about the algae that was on the deck. He certainly did not know about the slippery of the algae on the deck until he actually fell.
Well, and that may be an important distinction, Mr. Lee. As I understand the cases, Prattis and many other cases like Prattis, just to appreciate there's a deck there that may be obvious is not the analysis point. You have to appreciate the danger. And it would be your position, your client's position here, that the danger was the slipperiness of the deck?
That's correct, because he didn't step through a board that was rotted through, and that's how he got injured. It is very clear from the evidence, and I think it's pretty undisputed, that he slipped on algae that was on the deck.
Is there any evidence in this record that Mr. Williams knew this deck was slippery before he fell?
No.
Is there any evidence that he knew there was algae or mold on this deck before he fell?
No. So there's nothing like that, and what there is evidence of is that the defendant Weaver absolutely knew about it, and we know that because he testified about the algae being something that was really an ongoing problem. He took it upon himself, and I say take it upon himself, he did some, what he called maintenance. He also had other people come in and spray some things on the deck to try to get rid of it at various points in the year. I think it was an annual thing at one point. But at the time that Mr. Williams fell, we know for a fact that he hadn't done that. And we know that because Mr. Weaver said it. He admitted that he really hadn't kept up with that, and he didn't remember the last time he did that. And so the algae, yes, can you look at the deck and see that it's not a pristine deck? Of course you can. I mean, the picture shows that. But the danger of what he actually slipped on, the algae, was not known to them, not known to him. And what the trial court did was the trial court looked beyond what we think was clear evidence in this case of that and said, well, he should know because everybody knows that algae's slippery. That's what the trial court said.
Why can't the trial court do that under the new standard, though?
I don't believe he can because of the fact that there is evidence directly to the contrary. It is not, I don't believe that this is one of those situations, and you see cases that's been cited like Brookie, where there's a pallet in the middle of the way that you can kind of see it off the ground, you know, and those kinds of cases where there's a speed bump, right, that you can see. With algae on a deck, there is no case that I know of, I don't think there's any case cited to this court that says absolutely, if you see algae, that means it's slippery. There was no evidence of that. And so for the trial court to make that supposition without any evidence in the record to support it, we believe went beyond what he could do in a summary judgment setting. There was certainly a dispute of material fact as to whether the algae was slippery. And oh, by the way, Mr. Weaver didn't say it was slippery. Mr. Weaver said in his testimony he didn't even know it was slippery.
Well, and how do you reconcile that, Mr. Lee? Because, and I've got the trial court's judgment. The trial court held that no reasonable jury could determine that the deck was anything but an open and obvious condition, and you're saying Mr. Weaver said that he didn't know it was slippery. Mm-hmm. So the owner, who walked by it almost every day, didn't know it was slippery, but the court said no reasonable jury could determine that the deck was anything but open and obvious. How do you reconcile those things?
I can't, frankly, because I think the second point to that is that Mr. Williams didn't have the duty of care to Mr. Weaver. Mr. Weaver had to Mr. Williams. It's a knew or should have known kind of care. And so even if Mr. Weaver says, I never knew that it was slippery, a jury could look at the evidence in this case and say, we think you should have known that. And that's where the trial court, I think, went awry. There were missing pieces of evidence that Mr. Weaver did not present to the trial court that were necessary for the trial court to come to the rulings that it did. And so what the trial court did was he backfilled those pieces of evidence, like the one you've already mentioned, that, well, everybody would know it was slippery. Well, that's not what the evidence said. There was nothing in the evidence that said that. And so there was no reasonable basis for a trial court to make that kind of statement when there literally is no evidence to support it.
Where do you draw the line? What if it was ice? Would the judge be able to say, everybody knows ice is slippery?
I don't think that's a line, frankly, that a judge can draw in that situation. When you're talking about...
What if the judge said everyone knows water's wet?
Water's wet? Sure. Water is slippery on a deck, or you can slip on water on a deck? That's another thing. Because we're not talking about just the properties of a liquid. You know, we're talking about, and as this court knows, I'm sure a lot of attorneys know, there's a big difference between water on a wood surface versus water on a tile surface versus water on a grippy surface, right? I mean, there's all sorts of things where water, in one instance, an expert could come in and say, yep, that water was slippery because of X, Y, Z. And then another expert could say, no, it wasn't because of X, Y, Z.
But your contention is that the judge went too far by saying everybody knows algae is slippery. I'd like to know where you draw the line on what the judge can say is obvious and not obvious.
Judge, I think that is a line, I mean, and frankly, my standpoint is the judge shouldn't be drawing that line
At all.
at all.
Ice is not slippery.
That ice is, I do not think. Now, I will caveat that by saying that if there's evidence in the record for that, I mean, if Mr. Weaver had brought in evidence that said, look, you know, or it's a hypothetical. He came in and said, you know, I told Mr. Williams that was slippery because I had slept on it before, and so he knew that. That type of evidence can then lead to that inference that, well, you knew it was slippery, because it's not, I think we're getting into sort of everybody knows it's slippery. That's not the standard. It's whether Mr. Williams did.
Well, it kind of is, isn't it? If the judge said no reasonable jury could find, then the standard is everybody kind of has to agree that we all know this.
True. I see what you're saying, but when you are talking about what no reasonable jury could or could not find, that can't be a statement you make that disregards every bit of evidence in the case.
Okay.
And I see I'm coming up on my time. If there's no more questions at this point, I'll save the rest for rebuttal. Thank you.
Thank you, Mr. Lee.
Good morning. May it please the court. Lara Edelstein on behalf of the appellee, Mr. John Weaver. It's our position that the trial court properly granted summary judgment in this case in favor of my client, where Mr. Williams, as this court acknowledged, was an employee of an independent contractor while he was on Mr. Weaver's property. He was performing work that he was hired to do when he was hurt. Now, the appellant would say that delivering the paperwork to the front door was not a part of his job, not what he was hired to do, but it was part and parcel of his job. He was there to perform work on the lawn, and he was crossing the lawn to leave paperwork at the front door. This was
So assume all that to be true. What is our standard?
the trial court properly found that the standard is the independent contractor standard as set forth in our brief. And the case law says that a landowner is not liable to an employee of an independent contractor who was hurt on the property performing the work that he was hired to do. And there are two exceptions to that.
What was the work he was hired to do?
He was hired to do lawn, like spraying, fertilizing, something like that, weeding and fertilizing on the lawn.
Okay, very similar to the Strickland case that they mentioned in their brief as working on the roof and then falling through the roof. Correct? So, I mean, but he wasn't hurt doing the duty of spraying the lawn. He was hurt when he was delivering the paperwork. Is that correct?
That's correct.
But you would still consider that in the scope of his employment?
I do, Your Honor. I mean, basically, he wasn't heading to the front door for any reason other than something in furtherance of his job. He wasn't going to the front door to, you know, get out of the sun or get out of the rain or anything to those, you know.
How do you distinguish that from the Strickland case that he cited?
Your Honor, like I said, it was in furtherance of his job. The Roberts case that we cited to, rather than the Strickland case, is more analogous to this case. And in there, Roberts versus Dacra Design, the plaintiff was an independent contractor who was working on an air conditioning unit in a dark room that had no electricity. He was responsible, the contractor, was responsible for lighting the area and doing the work. And he slipped and fell on pipes that were on the floor that were unrelated to the work for the air conditioner repair. And the trial court found that there was no liability, and the appellate court affirmed on appeal.
Those pipes were connected to the air conditioner?
I'm sorry?
Those pipes were connected to the air conditioner?
They were
correct?
unrelated to the air conditioner.
Unrelated.
And so the court found that the pipes were there to be seen upon any reasonable inspection of the work area, and that here the same thing applies. Mr. Williams was here to do lawn work, but he should have done a reasonable inspection as he was walking towards the patio. In his own words, the patio was old and dilapidated. It was filled with algae to the point that it had a greenish tint to it. And so
Well,
it's,
he said those things after the fact, correct? I mean, that was his appreciation after he fell.
that's correct, Your Honor, but it sounds like it's something that was open and apparent, open and obvious for him to have noticed prior to slipping on it.
Let's go back to my question I asked a couple of minutes ago. Assuming he was an independent contractor within the course and scope of his independent contractor relationship with Mr. Weaver, you said there are two exceptions. What are those exceptions?
Yes, Your Honor. So the two exceptions, the first one is that the owner is controlling the work. And we know, and I think it's undisputed, that that doesn't apply here. Mr. Weaver wasn't at home, and there was no evidence that Mr. Weaver had ever given any kind of direction to Mr. Williams or his employer as to how the work should be done, other than, I think he said something like, he wanted to make sure that both the front and the back lawns were
And the second
treated.
exception?
And the second exception is that the owner fails to warn the contractor of a concealed or latent danger not inherent in the work for which the owner had actual or constructive knowledge and was unknown to the contractor or could not have been discovered through due care. So a couple of things there. There was not a concealed or latent danger. The algae on the deck was open and obvious. It was there to be seen. Apparently, it had a greenish tint to the wood, and the deck appeared to be old and dilapidated. So there was
What do
not.
you do with, and you heard my question to Mr. Lee, as I understand the cases, Prattis and Brookie, all the cases, say that the open and obvious nature of this needs to go to the danger here being if it's slippery or not. And your client said he didn't know it was slippery. How do you reconcile that with finding this deck being an open and obvious danger?
Well, the fact that Mr. Weaver testified that, number one, he didn't think it was slippery, but he did take precautions in maintaining the deck, and as well as the fact that he said that nobody else, he knew of nobody that ever walked across the deck, and nobody ever complained of walking across the deck and finding that it was slippery.
Well, didn't he say, I read his testimony before we got here, I thought he said pictures were taken out on this deck, the bench was used for those pictures, there were people that walked over the deck. Are you saying that was not his testimony?
His testimony was that the family took an annual picture on the deck, and so once a year, they sat on the bench that was there and took a picture. So I don't know that that necessarily means that people were walking on it all the time, which in fact he said that they weren't, and he didn't know of anybody that walked on it. He didn't walk on it, and he was unaware of anybody, vendors or friends ever using the deck. In fact, he said that they would park on the other side of the house and use the driveway to walk up to the front door.
How could it be so open and obvious that no reasonable jury could determine that it was anything other than open and obvious when the owner walked by this deck all the time and didn't think it was slippery?
Well, at the time that this happened, Mr. Weaver was not present. They had another home out of the state of Florida, and so he and his partner were not at the property at the time that this happened. But yes, he did say that he would walk out of his front door and towards the driveway. He said he didn't necessarily inspect the deck all the time, but he walked by it, and when he would notice that it was in need of cleaning or to spray it for treatment, he said once or twice a year he would spray it with a product to maintain the moisture of the wood and to clean the algae from the wood. So Mr. Weaver is not in any superior knowledge to Mr. Williams to know whether or not the deck would be slippery. But in fact, Mr. Williams, who's in the lawn maintenance business, would probably have a superior knowledge to my client. And in fact, he did testify that he normally does not walk on the grass when he's doing his
How would
treatment.
Mr. Williams have superior knowledge when your client testified that he walked by this deck almost every day with his dog when he was there?
Well, the fact of the matter is that Mr. Williams is a lawn maintenance worker, and Mr. Weaver is not. And so the fact that Mr. Weaver also testified that he routinely chooses not to walk on the grass when he does the treatment, especially when it's wet, goes to show you that he had some intention of where he was going to step. And when you look at the pictures, he had to have at least made one step in the grass before he actually got to the deck. And he did say that the grass appeared to be wet that morning, although he didn't think it had rained.
As you know from Mr. Lee's initial brief, and he may have raised it in his reply brief, he certainly raised it in his initial brief, even applying the independent contractor standard, it's his position on behalf of his client that there's still a duty of reasonable care. Mr. Weaver owed Mr. Williams a duty of reasonable care. I see that in Prattis. Help us understand that. Is there a duty of reasonable care even if he was an independent contractor?
Yes, Your Honor, there is. And the testimony of Mr. Weaver is that he did maintain the deck once or twice a year. He had it pressure washed. He either did it himself when he was younger or had his sons do it. And then he also, like I said, treated it once or twice a year with this chemical to moisturize the wood and also clean the algae from the deck to keep it mold and mildew free. So there is testimony in the record that shows that he did use reasonable care in maintaining the deck. You know, we all know we live in Florida. It was 7:40 in the morning. There might be morning dew on the grass. Maybe there was some testimony about the sprinkler system. Perhaps the grass had been wet that morning because of the sprinklers being used. And so, and the deck where the area was where Mr. Williams fell.
If I may, and I'm reading from your brief, your answer brief. It says, Weaver stated the deck was in need of cleaning. Some of the coloration was due to age and some of it needed to be cleaned. I guess this was after he was shown the picture. So wouldn't that go to reasonable care if your client stated the deck was in need of cleaning and some of it needed to be cleaned?
Well, just because it needed to be cleaned doesn't mean that Mr. Weaver didn't use reasonable care. The fact is that this was outside. This is under a tree in Florida weather. Is it reasonable for the court to hold Mr. Weaver to cleaning it more than once or twice a year? Does he have to clean it every month, every week, every day? So when Mr. Weaver testified that he cleaned it and maintained it once or twice a year, and he didn't say that the pressure cleaning and the chemical treating were done at the same time. So, you know, possibly the deck is being maintained throughout the year, either being pressure cleaned or being chemically treated. So how many times a year is reasonable? And so
Isn't reasonableness a jury question?
it typically is, but in a case where the issue is duty of care or a duty, it is one for the trial court to determine as a matter of law.
Even with your client saying the deck was in need of cleaning, that should have been determined as a matter of law?
I don't know that there was any elaboration of what he meant by cleaning. So, you know, there could have been debris on the deck that he was seeing versus algae. I don't know what he was seeing or what he was referring to when he said that it was in need of cleaning. But certainly it doesn't sound like, you know, that he was unreasonable in maintaining the deck. Like I said, he did maintain it several times a year. And so, you know, if the court's going to try to find that, you know, a certain amount of times a year is reasonable and other amounts are unreasonable, I don't think that's where the court wants to go, especially when we're talking about, like I said, something that's outside in Florida weather, you know, born to the elements of the weather. So,
How do we evaluate that as a panel? What is reasonable and what is not reasonable? And is that quintessentially a jury question, or is it a legal question?
Well, like I said, the cases say that the question of duty is always one of law and not for the jury, and so,
And I understand duty, and I think we all agree here that your client had a duty of reasonable care. I'm talking about reasonableness. Is that an issue for the court or an issue for the jury, or can it be an issue for the court in certain circumstances? That's what I'm trying to drill down and understand.
oh, like I said, I mean, I do agree that typically reasonableness does go to the jury, but in this case, I think that the evidence shows that Mr. Weaver did take reasonable steps to maintain the deck several times a year, and the trial court was proper in finding that he wasn't liable for Mr. Williams' injuries, based on everything, based on the photographs, based on Mr. Williams' testimony, Mr. Weaver's testimony, and the fact that the condition of the deck was open and obvious for Mr. Williams to observe. And I think it's not necessarily genuine that Mr. Williams says that he saw how utterly dilapidated the deck was and covered in algae where he walked afterwards. I think that as a matter of sensibility, he would have seen it before he actually stepped on the deck. And knowing that he had this rule in his head that he typically didn't walk on the grass, and specifically not wet grass. And so you would think that he would be walking carefully where he was stepping to get to the front door. And what also that came out in the testimony was that he was wearing rubber boots. So I think that's kind of interesting that he would take that step into the grass, like against his own better judgment. And so, based on all of the circumstances, I think that the trial court was eminently correct in finding that the condition was open and obvious, that there was no concealed or latent danger that Mr. Weaver was responsible for warning Mr. Williams about, and that Mr. Williams could have reasonably inspected the deck before he took a step to determine that maybe he should have gone to the driveway and walk around like everybody else did. If there are no further questions, I would ask that the court affirm the summary judgment. Thank you.
A couple things I wanted to address. Obviously, the duty of care is something that a trial court can determine. They can do that. And so, and obviously this court has the ability to overturn that because it's a de novo standard. When we're talking about whether something is reasonable, whether a defendant was reasonable in inspecting or, cleaning 4 times a year, 3 times a year, 1 time a year, that is a quintessential jury question. There is not a case that I know of that says that a trial court, because to make that kind of statement, to make that kind of ruling, the trial court would necessarily have to weigh evidence. The trial court would have to say, I think from what he said that that's reasonable. The trial court absolutely cannot do that. There is no case that says they can do that. Even with the new standard, I call it the new standard, it's not really new. Even with the new standard, the trial court cannot weigh evidence. It is where there is a genuine dispute of material fact. There absolutely is in this case. And so the fact that the defendant agrees that there was a duty of care, the case law talks about, even with independent contractors, there's a duty of care to maintain the premises in a reasonably safe condition. Has that duty of care, doesn't matter whether it's an independent contractor or not. And the trial court took that and said, well, I believe him, and so I'm going to grant a summary judgment for him, for Mr. Weaver. He couldn't do that. Absolutely could not do that under the law. And so because of that, and because of the other reasons we've set forth in our brief, a host of reasons, this court should reverse the trial court's final judgment and allow the jury to make those determinations as they should have in the first place. Thank you.
Thank you, Mr. Lee. Thank you both. It was well presented on both sides. Mr. Lee, I don't know if you're with us for the next argument. I believe you are. Switching. So we'll give you a chance to switch chairs, and counsel for the appellant can come forward on our next case.